The history of affirmative action in terms of the court has been a consistent narrowing in terms of the court over time finding that more and more affirmative action plans are unconstitutional.
This session, the Supreme Court will decide Fisher v. University of Texas, a case with far-reaching effects on affirmative action in higher education. The court heard the case last fall. Abigail Fisher, who is white, claims that the school violated her equal protection rights when it failed to admit her in 2008.
She subsequently sued on the theory that there were minority students who had differing qualifications that were admitted in the year that she applied.
The university automatically accepts the top 10% of in-state applicants, while the remaining 90% are judged against a variety of criteria, including academic performance, extracurricular activities, and yes, race.
The question the court will decide is whether, in fact, the admissions scheme that was used by the University of Texas, the one under which Abigail Fisher was not admitted, whether that actually violated her equal protection rights.
The school argues that its policy complies with the law and points to the Supreme Court's decision in 2003's Grutter v. Bollinger. In that case, the court decided that the University of Michigan Law School can use race as a criteria for academic admission as long as it's only one factor among many.
The court basically has said that the use of race in higher education was different and special. And that's really what Grutter was all about. I believe that Fisher's argument is the following, that even though Grutter had said you could use race, in a situation like the University of Texas, where they had experimented and they had found a way to achieve some meaningful level of diversity, that there was no more of an additional justification to use this race as a factor to get additional amounts of diversity.
How the court decides could hang on whether the justices adhere to the precedent set by Grutter. At the time, former Justice Sandra Day O'Connor wrote in the majority opinion, "We expect that 25 years from now, the use of racial preference will no longer be necessary to further the interest approved today."
Justice O'Connor's opinion there really gave a lot of room for universities to be able to use race consistent with their educational mission. I think Fisher's already had a tremendous impact on affirmative action because universities are on notice now that the court is very open to these kinds of arguments. They may be thinking twice and three times about whether in fact they can continue with the kind of plans they've used consistent with Grutter. It's quite possible that you might have a leveling where all uses of race in all contexts basically are viewed the same, which is with extraordinary skepticism.